Okay.
Your Honor, my name is Enoch, and along with my co-counsel Amanda Stearns, we represent the plaintiff in this case, Quinn Chase. Good start. Today's case is a dram shop liability case, and my co-counsel has a notice of appearance for your convenience.
Okay.
Your Honor, we also would like to offer a notice of intent to use popular names. There are several names in today's case that are based off of popular names that have been altered slightly. And just for the court's reference, in case we slip up in the names, may I approach and tender?
Mm-hmm.
And per rules of AHA, we have no pretrial motions.
Okay. Anything from the defense before we get started?
I would just like to introduce ourselves. My name is Jordan Cox.
Okay.
And Laura Hobbs.
They would represent the defendant, Continue Enterprises LLC.
Okay. Anything from you before we get started?
No, Your Honor.
Okay. Plaintiff, you may proceed with your opening statement.
Thank you, Your Honor. May it please the court,
Yes.
and ladies and gentlemen, members of the jury. A man walks into a bar. Typically, this is the start of a good joke, but in today's case, it is not. This man walked into a bar, took shot after shot after shot, was thrown out of the bar, and proceeded to get in his vehicle. Then he ran a red light. Then he ran into our client, sending her to the hospital. This is no laughing matter. This case is about a bar selling alcohol to a visibly intoxicated person. Members of the jury, I'm Enoch Hicks, and along with my co-counsel, Amanda Stearns, we represent Quinn Chase. And before we get into what all the defendant did and didn't do in this case, I would like to take this opportunity to introduce our client, Quinn. This is Quinn. She's currently a graduate student at Spring Stream University. That's over in New Jersey. She's actually a local resident right here at Steelton, and she's an alumnus of Steelton State. And Quinn, the most important part about Quinn today is that she's a victim. She's a victim of a bar selling alcohol to someone that was visibly intoxicated. And today, we're going to show you this through the evidence and testimony presented right here. We're going to show you by the preponderance of the evidence that the defendant, Montana Max's Good Time Saloon, sold alcohol to Al Overton, that driver that I spoke of. They sold alcohol to him when he was visibly intoxicated. And they threw him out of his bar. As Al left that bar, he jangled his keys around for all to see. Now we're going to show you this by the preponderance of evidence. And you might wonder, what does that mean? It just simply means that after hearing all the evidence and testimony that we present here today, if you believe what we show you just slightly more than the defendant's story, you must find the defendant liable for their actions. Now let's get down to the facts of this case. We're going to present to you three witnesses today. The first being Al Overton, the driver of that vehicle, the person that drank all those drinks. However, this might be presented in a way that you are not used to seeing on TV or if you've been a juror before. Today we're going to present Al's testimony from a previous deposition. This is sworn testimony that we're going to read to you. Through this testimony, we're going to show you that Al arrived at the bar at 10:30 p.m. on January 7th, 2013. He was there to celebrate his birthday. That was going to be occurring on January 8th at midnight. He stayed at that bar. He had drink. He had shots. He had some beer. Then he left that bar and got into his vehicle and ran into our client. Ladies and gentlemen, we ask you that you put the same amount of weight on this testimony as any other witness here today. Next, you're going to hear from Cindy Crosby, a local business owner and a local resident here at Stilton. We've hired Mr. Crosby to come in here and give his expert opinion based on his ability, based on his experience in the serving of alcohol and hospitality. Mr. Crosby analyzed all the facts and all the information related to this case, and then he came to his conclusions. Those conclusions being that the defendant, Montana Max's bar, sold alcohol to Al Overton when he was visibly intoxicated. And as such, when he ran into our client, it was the bar's fault. Crap, I messed that up. Next you're going to hear from Quinn Chase herself. Ms. Chase, prior to going to do her graduate studies in New Jersey, she did her undergrad here at Stilton State. And like most undergrad students, she enjoyed her time. She had an off-campus apartment with her best friend. And in the afternoon prior to this collision, she was at that apartment. She was having a bit of a watch party for the BCS National Championship game that was occurring. And you're going to learn at this party there was some alcohol. And Ms. Chase had some of this. You're also going to learn that those few drinks that Ms. Chase had, they were over a 7-hour period. And after that party, Ms. Chase had some plans. And this was around 2 a.m. So she gets in her vehicle, and she's driving down State Route 60. She's right outside Montana Max's bar. She sees in front of her a green light. The traffic's flowing. What'd she do? She goes through the light, just like everyone else. That's when she's T-boned, though, by Al Overton. She's T-boned, and she's sent to the hospital. Members of the jury, we shouldn't be afraid to leave our homes, no matter what hour it is. And it's possible that during the defense's case today, they might try to blame Ms. Chase for this accident. Let's not be distracted by these allegations. Let's focus on the facts of the case. Like I said earlier, this is the night of the BCS National Championship game. And you're going to learn that it was also Al Overton's 21st birthday. And he's going out with his friends. He's going out to have a good time. And there's nothing wrong with that. But that's not what this case is about. This case is about the bar selling Al Overton so much alcohol he became visibly intoxicated. That he got in a fight with his friends, that he got in a fight with the bouncers, that he vomited in the bar, and then he knocked over a bunch of trays. That's all my good points. This case comes down to TLC, which I totally freaking forgot to say earlier in the opening, but TLC, which is training, language, and conduct. The bar claims that they trained their employees. We'll show you today that is not true. They purportedly use this training for intervention procedures, which shorthand is TIPS. TIPS focuses on training, intervention, and practice. But listen today how long it's been since Montana Max's put their employees through this program. Additionally, listen for the shot girls that this bar brings in on particularly busy nights. These girls wander around the bar selling you shots. Listen how these girls aren't trained properly like the rest of the employees. Additionally, Montana Max's has policies that they require their employees to follow. We'll show you tonight that the bar did not follow these policies, particularly in regard to how the bar didn't keep track of the drinks and how They didn't focus on the signs of intoxication. The next key to this case is language. The language that Al Overton used when he was in the bar. Like, it's my 21st birthday, and I'm going to take all these shots. This language is key for the bar to know that Al Overton possibly might have become a visibly intoxicated person, and for the bar to take extra steps. And finally, conduct. The bar failed in their conduct when they served Al Overton. They served him to the point that he vomited. They served him to the point where he was in fights. They served him to the point that he was knocking over trays. They served him to the point that they actually escorted him out of the bar while he was holding his keys in the air. They failed in their conduct. Members of the jury, your job tonight is simple. Pay attention to the evidence. Don't get distracted by things that don't matter. At the end of this trial, my co-counsel, Amanda Stearns, will return to speak to you once more. And during that time, we're going to ask you to find the defendant liable for their actions. When a bar serves a visibly intoxicated person, they have a duty to the community. When that bar throws that person out, they've breached that duty. Thank you.
Defense?
May it please the court. Responsibility, risks, and rules. That's what today's case is about. We'll show you that a business like Max's can fulfill its responsibilities, minimize its own risk, and follow the rules. But doing so cannot prevent others from acting with free will to break the laws and injure others. Ladies and gentlemen of the jury, I'm Lauren Elvis, and my co-counsel and I, Jordan Cox, are proud to represent Montana Max's Good Time Saloon. Montana Max's is a local restaurant that has something to offer everyone. Good food, arcade games and prizes for families with young children, and specials for local college kids. Max's employs dozens of bartenders and servers and other staff. And as part of this, Max's trains its employees to follow the rules. Today you will learn that Montana Max's has appropriate policies in place to train its servers on responsible service of alcohol, and that on January 8th, 2013, they followed those policies regarding Al Overton. You'll learn that it was Al Overton himself who then made a choice that resulted in harm to the plaintiff. Now, as you hear the evidence and testimony today, we want you to keep in mind the three things that we've already talked about: responsibility, risk, and rules. So let's take number one, responsibility. When anyone drinks, they are personally responsible for what they drink and the consequences that follow. All alcohol labels and demonstrate this by warning to drink responsibly. Now, when a person enters a restaurant and begins consuming alcohol, that restaurant shares the responsibility to ensure that patrons do not become a danger to themselves or others. Max's embraces this responsibility. But how far does a restaurant's responsibility extend? Today we will show you that that responsibility does not require restaurant staff detaining a patron who tells staff he has a ride home, and it does not require following that patron to a separate parking lot where they decide to drink in their vehicle for a half hour before driving. Today you're going to hear a lot about Al Overton. You'll learn that Al Overton was a young man who went out on his 21st birthday looking for a good time. You'll learn that at about 10 or 10:30 p.m. on January 7th, 2013, he arrived at Max's to continue the celebration with his friends. You will learn that Max's staff did indeed serve Al alcohol. We're not going to dispute this. But you'll also hear that before leaving, Al told staff he had a ride home. And that after leaving, Al crossed the street to a separate parking lot where he sat in his car for 30 minutes and drank round-up liquor. Max's does not sell that type of alcohol. You're also going to hear a lot about the plaintiff, Quinn Chase. You'll learn that before driving that night, Quinn chased for a huge kegger where he had 4 to 5 beers and shot a fancy whiskey he just had to try. You'll also learn that after leaving this party, he drove to pick up a date at 2 a.m. and was on the phone with the state while driving. You'll learn that the collision occurred during this phone call. So many unneeded risks. You'll see that Al Overton risked the safety of himself and others by drinking before driving. and that the plaintiff, Quinn Chase, took the same risk of drinking before getting behind the wheel, as well as talking on the phone while driving. And so in that, we turn to rules. Today you're going to hear from Montana Max's owner, Max Petunia. Keep in mind that Max is the only witness you will hear from today that was in the restaurant that night. You're going to learn that Montana Max's has a policies in place called TIPS, which stands for Training for Intervention Procedures. TIPS trains Max's staff to serve alcohol responsibly. And you'll see that TIPS trains staff to monitor alcohol consumption, as well as identify intoxicated persons, so that employees don't overserve and let people who should not be driving get behind the wheel. You'll also hear from Max that Al Overton did not appear intoxicated to him, and that before leaving, Al told staff he had a ride home. You'll also learn that TIPS has staff look out for 21st birthday parties just like Al. Max will tell you himself that he saw Al that night, and that he's seen and dealt with 21st birthday parties like Al's before. Max will tell you that for this reason, he kept an eye on Al. And now you'll also hear from expert Dr. Gene Malkin. Dr. Malkin is educated in pharmacy, toxicology, and pharmaceutical chemistry. Dr. Malkin is also educated in the hospitality standards for the responsible service of alcohol. Dr. Malkin will tell you that Max's TIPS system is satisfactory in training its staff to serve alcohol responsibly, and that they follow those policies that night. Dr. Malkin will also explain that Max's staff were not required to detain Al, and that they were not obligated to follow him to the parking lot and babysit him while he sat in his car. Most importantly, Dr. Malkin is going to explain that Al's BAC could not have been high enough for him to exhibit visible signs of intoxication while at Max's. His testimony will corroborate the lack of eyewitness testimony that Al was visibly intoxicated while at Max's. At this point, we want to make something clear. We are not defending Al Overton. He is not our client. We are here to show you that Max's follows a responsible alcohol training program, and that they follow those policies that night. And because they met their responsibilities by following the rules, Max's is not to blame for this accident. But it's important to note that as the defendant, we don't have to show you anything. The plaintiff has the burden of proof here. And their burden of proof is called preponderance of the evidence, or more likely than not. That means that the plaintiff has to show you that Max's actions, more likely than not, caused the plaintiff's accidents and injuries, rather than the plaintiff and Al Overton himself. And the standard that they have to show you is called the reasonable person standard. So they have to prove that Max's did not act like a reasonable bar owner would in dealing with Al Overton. And what does that mean? Well, in Steelton, the government has set out laws that tell us what a reasonable bar owner would do. And as the judge will instruct you, a reasonable bar owner is not permitted to serve alcohol to a visibly intoxicated person. We're going to show you today that the plaintiff cannot meet their burden. They're going to point to certain things that happened that night and stress that these things show that Max is to blame for this accident. But keep in mind, that's their version of what happened. And they will not present a witness today who was there that night. Instead of getting eyewitnesses, they're going to call Sidney Crosby to the stand. When you think about who he is, and you learn what he does for a living, think about whether or not he has skin in this game. Ladies and gentlemen, you'll see that this case is all about rules, risk, and responsibility. And we will show you that Max has met its responsibilities and followed the rules. And that this accident was caused by the risk taken and lack of personal responsibility of two people, Al Overton and Quinn Chase. Thank you.
Plaintiff, you may call your first witness.
Are we gonna do Al?
Your Honor, before we begin, two matters to address. Plaintiff would like to make notice to the court that the plaintiff is only pursuing a charge of negligence and not a negligence per se charge.
Okay.
Second, we would also like to take this time and opportunity to read portions of Al Overton's deposition. Al Overton is an unavailable witness, and if the court would approve, I would have my co-counsel take the witness
Go ahead.
Reading from page 27, line 6. Please state your name for the record.
My name is Al Overton.
Mr. Overton, where do you live?
I just moved to Lone Star.
Moving to page 28. What do you remember about that night? Let's start with when you got to Max's.
We got there around 10 to 10:30. The football game was on and we were getting ready to celebrate my birthday.
Okay, I will ask you about that in a moment, but first, did you have anything to drink before midnight?
No, sir. Pretty much the whole bar knew it was my 21st birthday. My friends kept telling everyone that I was going to do 21 shots.
Moving to page 29. Okay, have you ever had alcohol before your 21st birthday?
A little beer, a beer here and there. I never had any hard liquor.
Have you ever been drunk?
Maybe once or twice.
Do you know how many shots you had?
5 or 6.
And you still say you were not drunk?
I was not. It was over the course of 2 hours. I had a beer that I was nursing the whole time, and I did a shot about every 15 minutes.
How much do you weigh?
I'm about 185.
Is that the same at the time of the accident?
No, I've lost some weight. I was around 225 then.
Did you and Max interact at all that night?
Sure, everybody knows Max.
Line 15. Did you and Max interact at all that night?
Max yelled at the bouncers to kick me out. Max said he did not need some kid who had his first pop getting sloppy and ruining the night.
What happened next?
I held up my keys and said I was going to Michigan Mike's.
Page 31, line 2. Did you have anything else to drink?
Do you mean booze?
Yes.
No.
What about the half-empty bottle of Bad Dog in your back seat?
I did not have any of that to drink.
What color was it?
It was purple.
And didn't you have purple stains on your shirt when you were arrested?
That was from one of the shots in the bar.
Nothing further at this time, Your Honor.
Anything from the defense?
Your Honor, we do have select portions from the same deposition we'd like to read in, but we would like to reserve that opportunity for our case in chief.
Okay, that's fine.
Thank you.
Call your next witness.
Your Honor, at this time, plaintiff calls Sidney Crosby. Permission to set the courtroom for a demonstrative?
Yes.
And he had me print off the subpoena before y'all went.
Judge gets GSA that you told me about, so I'm not gonna let you. You need to send.
Judge Blake?
Yeah, you need to send me a letter, and I'll consider it whether I'm gonna allow it.
What do we have to get a order to compel from the district?
Yeah, and then we email Judge Seymour. I'm gonna need it over for you.
Could you please introduce yourself?
My name is Sidney Crosby.
Where did you go to school?
I went to school right here in Stilton State.
What degrees did you earn?
I got a degree in hotel and hospitality management.
Do you have any other advanced training or degrees?
Sure, I'm a certified stock instructor.
What do you do for a living now?
Well, currently I'm the general manager at Michigan Mike's Marvelous Malts and Microbrews.
Where is this located?
It's right here in Stilton also.
Are you aware of a place called Montana Max's?
Oh, yeah, sure.
And where's Montana Max's located?
They're also another bar and restaurant here in Stilton.
Mr. Crosby, due to the nature of both businesses and the location, would you consider Montana Max to be a competitor?
Sure, I would, along with the Tilted Kilt and Buffalo Wild Wings and several other establishments here in town.
Does this competitiveness at all affect your professional analysis in today's case?
No, it's a college town, so there's always going to be competition.
Speaking of your professional analysis, what did you do for today's case?
Well, you contacted me and asked me to review all the materials and facts of this case and make a determination on the training and level of training that the employees at Montana Max's used in the early morning hours of January.
Are you aware of the training method that Montana Max uses?
I believe they use the TIPS method.
And do you have experience with this method?
Absolutely. I've written some articles on it and very knowledgeable about it.
What did you review in today's case?
Well, I reviewed all the depositions, the exhibits that you provided me. Specifically, I reviewed Montana Max's training procedures for the service of alcohol and intoxicated patrons.
And how did you analyze this information?
Well, I tried to use the depositions to determine what happened that night and then compare what happened to Montana Max's own policies and procedures to see if they were even following their own procedures. Then I also compared their conduct to industry standards.
And is this analysis typical in your industry?
Certainly.
Were you able to do this analysis reliably?
Yes.
Your Honor, at this time, we would tender Sidney Crosby as an expert in hospitality and service of alcohol.
Any objection?
No objection, Your Honor.
All right, without objection, Mr. Crosby will be tendered as an expert in the field of hospitality and service of alcohol.
Mr. Crosby, what were your conclusions about the standard of care that Montana Max implemented?
Well, specifically, I formed 3 conclusions about the standard of care of Montana Max's employees that night.
Would it assist you to use a whiteboard to discuss these areas?
I'll be happy to, yeah.
Permission for Mr. Crosby to step down and make use of the whiteboard?
Yes.
Your Honor, permission to reposition myself in the courtroom? to see
Yes, you can
the
reposition. You don't need to ask.
Okay.
You mentioned 3 areas. What were these 3 areas?
I developed an acronym for these 3 areas. Our industry is very familiar with acronyms. TIPS, the training method that Montana Max has used as an acronym. STOP, the training method we use as an acronym. So I came up with the acronym of TLC. This acronym stands for the training, language, and content. The training training that Montana Max's employees were trained under on this night. The language that Al Overton used on the morning hours of January 8th, and the conduct of both Al Overton and Montana Max's employees.
Well, I want to take these areas one by one. So let's start with training. You mentioned earlier Montana Max implements the TIPS method. Can you explain what TIPS is exactly?
Sure. TIPS stands for Training Intervention Procedures. It's essentially the same thing ultimately as the STOP procedure, but just employs a little bit more role play.
What exactly is training intervention procedures mean?
Well, it just means that the employees notice signs of intoxication.
What evidence of any training did you find for Montana Max's?
Well, based on my review of the facts of the case, I could not find any training logs or any evidence of training. Although that their procedures do require training by a certified TIPS instructor every 6 months, I couldn't find any evidence of that. And so that's the first point for training. We couldn't find any records.
So what does this mean about the employees of Montana Max?
Well, Montana Max's on the night of January 7th and into the morning of January 8th had certain employees working there serving drinks who were untrained in the TIPS procedure.
Are you aware of which employees were serving Al Overton on that night?
I believe a number of the shop girls who are common in the industry, they walk around bars serving shots to patrons. A number of them were untrained. And so that's the second problem with the training.
Mr. Crosby, what was your ultimate conclusion about the training methods Montana Max implemented?
Based on the fact that there were no evidence of training records, and they were supposed to be conducting training every 6 months, the fact that many of the shop girls were untrained, ultimately, Montana Max has failed in the training of the tips procedure that night.
Now, moving on to the language portion of your conclusion, why was Al at Montana Max on the night of the 7th going into the 8th?
Well, we know from our review of his deposition that it was Al Overton's 21st birthday. He was there with his friends to celebrate.
And how did Al and his friends say they were going to celebrate?
Well, that's the thing. They came into the bar boasting of taking 21 shots that night.
Objection, hearsay.
Your Honor, we're not using these statements for the truth of the matter that they did in fact take 21 shots, but the effect that it had on the employees of Montana Max and being aware of the party's intent to overdrink.
Response?
I believe that her question was asking about what they said, or goes to like the nature of what they were saying or their plan, and so I believe that they are using it to, what's it called? Prove the
Truth
truth
of
of
the
the matter asserted, excuse me. What was the question?
Your Honor, the very next question goes into why this even matters, which establishes that it's not going for the truth that they did, in fact, drink 21 shots, but that the employees should have been aware that this was the plan or intent of the party and taken action towards it, which they failed to do.
Is there an exception for intent or plan to hearsay?
There is also.
Overruled.
Can you explain again what Al and his party were saying about their intent for the night?
Well, they indicated to several people in Montana Max's that night that they planned to take 21 shots in celebration for Al's 21st birthday. I can do it on the next one. Just let me do it. You said you'd ask me questions. I want to stay here. So,
Why does it matter that Al Overton and them were boasting about how much they were going to drink that night?
well, because the language that Al Overton and his friends were using that night should have indicated to the employees of Montana Max's that this was a dangerous situation.
Are you aware of a policy that Montana Max has?
Absolutely.
Would you recognize this policy if presented to you?
I would.
Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit D.
Okay.
What is this that I just handed you?
These are Montana Max's policies and procedures on the service of alcohol to intoxicated patrons.
Does it seem to be a fair and accurate copy?
It does.
Has it been altered in any way?
It has not.
Your Honor, at this time, we would enter what has been previously marked as Exhibit D into evidence as Plaintiff's Exhibit 1.
Any objection?
No objection.
All right, without objection, Exhibit D will be entered as Plaintiff's Exhibit 1.
Mr. Crosby, is the fact that Al was having a 21st birthday indicated as important in this policy manual?
Yes, it's in fact specifically mentioned.
Where is it specifically mentioned the importance of 21st birthdays?
In section 7.5, the section on preventing intoxication, it says, be aware of special events like 21st birthday or like birthday parties, especially 21st birthday parties.
So why is it important for the employees of Montana Max to be aware of the language of the patrons?
Well, this language should have served as a warning sign. Should have served as a warning sign to the employees of Montana Max.
And did this provide a warning sign to the employees on the night of the 7th going into the 8th?
No, they failed to act on the language of Al Overton and his friends.
Now jumping into the conduct that was demonstrated on the night of the 7th going into the 8th, when did Al consume his first drink?
We know that Al Overton started consuming drinks at midnight. That's when he turned 21, so the morning hours of January 8th.
And what were the first signs of intoxication that Al displayed?
Well, Al began stumbling and knocking over trays of drinks.
Did Al demonstrate any other signs of intoxication throughout the night?
He did. At a certain point, he got into an argument with his friends. They began to become loud and boisterous. That's another sign of intoxication.
Were there any other indications of intoxication that Al demonstrated throughout the night?
Yes, he also vomited at a certain point, and shortly after all these activities occurred, he was escorted out of Montana Max's bypass.
Mr. Crosby, I want you to look at Montana Max's policies one more time. Does it at all address these types of conducts, this type of behavior in the policy itself?
It does. It specifically addresses this type of behavior. Under section 7.4, observing behavior, observation of guests. Change in behavior is one of the best indicators of intoxication. For instance, a guest that enters the restaurant and is quiet, who then suddenly becomes boisterous and loud after a drink or two, should be observed carefully.
You mentioned that Al was escorted out of the bar. Can you explain exactly what happened during this time?
Yes, during that time, Al Overton held up his keys and said that he was going to drive to Montana Max's, or to Michigan Mike's, excuse me.
And does the policy address patrons who are going to leave?
It does. Policy specifically addresses conduct for patrons leaving. It's 7.6, procedure for an intoxicated guest who attempts to leave. You should never let a guest that you suspect to be intoxicated leave the premises. Always suggest calling a cab or having a friend take them home.
So overall, was Montana Max's conduct appropriate in this situation?
No. Based on the warning signs of the language, the lack of training, and the conduct that he displayed, and the failure of Montana Max's act on that, it was not appropriate.
Thank you, Mr. Crosby. You can take your seat. Take it with you. Mr. Crosby, why do restaurants and other hospitality entities have policies like that in place?
Well, these policies are very important because they outline how employees will react when a situation like this occurs. The policies for Montana Max's actually specifically address this. They speak to the employees that as employees, you are the first line of defense to ensure that customers have a good time, but do not put themselves or other members of the community in danger.
Mr. Crosby, what should have Montana Max employees done in this situation if they were properly using the TIPS technique?
If the employees were properly trained, they would have recognized the warning signs in Al Overton's language. They would have recognized the conduct that Al Overton was displaying throughout the night, and they would have acted to stop him from leaving when he held up his keys and said he was going to drive.
What should have Montana Max employees done if they were properly using their own policies on the night in question?
If they were properly using their own policies, they would not have served him after this happened, and they would not have allowed him to leave.
Mr. Crosby, what should an employee of any bar do in a situation like this?
They should not allow this to happen.
Thank you. Nothing further at this time. Permission to approach and tender plaintiff's one?
Yes. cross-exam?
Yes, Your Honor. Your permission to move this a little out of the way?
Yes.
Mr. Crosby, I want to talk about one of the warning signs that you pointed out today.
Okay.
You had vomiting, I was vomiting as a warning sign, correct?
Yes, I did.
But you also admitted in your report to this court that it could have been due to bad food, didn't you?
Sure. I was not there that night. It could have been due to bad food, but I don't think it's likely.
I also want to talk a little bit about your history. You do not have a toxicology or chemistry degree, correct?
No.
You don't have a degree in toxicology?
No.
You have no medical, chemical training or education whatsoever?
No, absolutely not. First aid. I'm trained in first aid.
You have a mixologist certificate?
I do, yes.
You are not a doctor?
No.
You're not a chemist?
No.
You're a bartender?
I think I do a little bit more than that, but that is one of my duties, yes.
You're also the general manager of Michigan Mike's, correct?
True. That is what I do for a living.
And that's to the left, about down the street from Montana Max's?
On Equally Drive, that's correct.
And they're direct competitors, aren't they, with Montana Max's?
Yes, as I said earlier, we compete with many establishments in town.
I want to talk a little bit more about January 8th, 2013. You were not there, correct?
No, unfortunately.
But you were asked to give an opinion about what happened that night, right?
That's true.
And you prepared a report for this court.
I did, yes.
And in preparing that report and forming your opinions, you relied on the depositions and exhibits in this case, correct?
I did, yes.
And you stated in that report, the last training session for tips that Max's had was 5 months before the accident.
I did, yes. That was a necessary assumption to make because I had no records of training, and so if training occurs every 6 months and we assume that it hasn't happened yet, it would be at least 5 months since training.
That leads to my next question. That statement is not anywhere in the materials that you reviewed.
No,
Is
it's
it?
not. I had no evidence of it, and so I was left to have to make the assumption that it had at least been 5 months.
You pulled 5 months up of thin air.
Well, it's only logical. It could have been longer, but it was at least 5 months.
You also stated in your report that most of the shot girls that night had not been trained, correct?
That's true.
So some of them have been trained.
It's just not really clear who has and who hasn't been trained. We just know that some of them weren't trained, based
So
on my.
That's yes to my question.
Yes,
Some of them
that
were
is
trained.
correct. That's right.
And you also stated in your report that 8 were working that night.
Yes, I believe 8 shot calls were.
But you don't know who specifically served Al Overton.
No, he was served by, I think at one time they were gonna take a shot from all 8, but I don't know if that actually happened.
So you don't know that any of the ones who did serve Al were not trained.
We know that some of them working that night were not trained. That's all I know.
So the shot girls who did serve Al could have been trained.
Some could have, but some likely were not.
And in his deposition, Max stated that all new hires undergo a rigorous training program, didn't he?
Objection, hearsay.
Response?
He relied on, under 703, an expert can testify as to the facts that they relied on forming their opinion without the underlying facts and materials themselves being admissible.
Your Honor, if that's the case, then I don't think she needs to elicit the statement and just simply ask him his opinion based on it.
Overruled.
Max stated, I'll just repeat the question, Max stated in his deposition that all new hires undergo a rigorous training program, correct?
Yeah, I believe I remember reading that.
I want to talk a little bit more about the events on January 8, 2013, okay? So Al got into an argument with his friends,
That's right.
and then he knocked over trade drinks,
Yes, another conduct on the board.
and then he vomited,
He did.
and then he got into an argument with the bouncer.
That's right, as he was being escorted.
And nowhere during the sequence of events did Max's staff serve him another drink, did they?
We don't know when the service would break out throughout that night.
That's all the questions I have.
Okay. Any redirect?
Yes, Your Honor. Also, permission to preserve my demonstrative for closing.
A little late, but okay.
That's why I was smiling at you.
Mr. Crosby, there is a lot of discussion about whether shop girls were trained or untrained. Whether they were trained or not, did they follow the training methods of tips?
No, they did not, and that's the biggest problem.
Did they follow the instructions provided in the policies of Montana Max's?
No, we've seen those policies.
Thank you, nothing further.
Does the plaintiff have any other witnesses it wishes to call?
Yes, at this time, the plaintiff would call Quinn Chase to the stand.
Would you please introduce yourself?
My name's Quinn Chase.
And why are you here today, Ms. Chase?
I'm here because back in 2013, my car was T-boned by a man I later learned was Al Overton.
What was the date of that collision?
The collision happened around 2:30 on January 8th, 2013,
Where were you living at that time?
here in Steelton.
Okay, before we get into the events of January 8th and the collision, what were you doing on January 7th, the afternoon of?
Well, that was the big night of the National Football Championship game in which Spring Stream University is playing, and I'm a pretty big fan of theirs. So my roommate and I, he's also my best friend, we decided to have kind of a party for the game.
How did your team do?
Unfortunately, we lost, but it was just a really big deal that we even made it that far, so it was good to watch.
So how many people were at this party that you had?
Over the course of the night, maybe 75.
What food and drink did you provide?
Just your typical party snacks, and then we also had a keg that we opened around 7 p.m. that night.
What else was there that night?
Well, everyone else kind of brought their own stuff, so there's a nice selection of alcohol, I guess, but we only provided the keg.
How much did you have out of the keg?
4 to 5 beers max.
And how do you know that?
I know that because I had a beer about every quarter on average.
You talked about how other people brought stuff. What did you have of those drinks?
One of my friends bought Johnny Walker Blue, which is really expensive scotch. It's like $200 a bottle. So he poured me maybe about a shot's worth of that, which I sipped over the course of an hour.
Okay, just so we're all clear, how old were you back then?
22.
Okay, and in total, how much did you have that night?
The 4 to 5 beers and that one little bit of scotch.
And when was your first drink?
Right around the time that we opened the keg, so 7 p.m.
And what time and what span of hours were all these drinks over?
I mean, I didn't get into the accident until 2:30, so it was at least 7 hours.
After the game was over and your event was over, what did you do next?
Well, after the game, I actually was supposed to go meet someone, so I got in the car and I was driving Montana Max's, but unfortunately didn't make it.
And what road were you driving on at that time?
It's the main street through town. I believe it's Route 60.
On the way there, what were you doing in your vehicle?
Well, the person I was supposed to meet called me, so I answered on my Bluetooth device, which really has the answer button on the wheel, so you don't have to move your hands and you can still watch the road, and then you just talk.
And you stated that you're driving on Route 60, and like, would drawing a diagram of the area help in your aid in your testimony here today?
Yeah, absolutely.
All right, at this time, I'd ask that we set up the courtroom for demonstrative aid
Yes.
and the witness to step down. Ms. Chase, you indicated that you're driving down. You indicated that you were driving down Route 60. Would you please indicate that with this blue marker? Now you left. What does this road lead to?
Well, Max's is over here, and then this is the parking lot.
And you stated you were driving down Route 60. Which direction were you headed?
I was headed straight.
And this looks like an intersection right here. What type of controls tell you that you had the right of way?
Well, this is, okay. So, there is a traffic light there. And I had the green light, so that was my light right there. And then that would be the red light.
Okay. When you were leading up to the intersection, how did you know you had the green light?
Well, I was following the flow of cars in front of me, and also I saw the green light.
Okay. A moment ago you stated that this was 2:30 in the morning. How dark was it out?
I mean, it was dark out, but there were street lights all along the way. So, pretty evenly spaced.
And where was your vehicle when the collision occurred?
Well, I was about right here.
And how did the other vehicle hit you? Usually we did thin flat, but yeah. We were going to save this one for last.
Sorry.
No worries.
So this was out right here.
Now you drew this vehicle a little bit to the back. Is that how the collision occurred?
Yeah, probably right around the gas tank area.
And you can return your seat. Chase, after the collision occurred, what did you do?
Well, the cops and ambulance showed up, and basically I was really injured, so I sat in my car until the ambulance took me to the hospital.
You indicated that a police officer arrived. How did you interact with this officer?
He checked all my injuries, and then really he was more focused on the other driver who hit me.
And just for clarification, Ms. Chase, where is Montana Max's on this diagram?
It's over to the left.
Thank you. I have no further questions at this time.
Any cross-exam?
Yes, Your Honor.
At this time, Your Honor, I'd like to preserve my democracy.
Yes.
Thank you.
I thought we were gonna raise, no, leave it, Honor.
You want me to leave it?
Yeah.
All right.
You're fine.
Can you bust
Honestly, I'm
notes at
broken.
this point and just be like, I'm not gonna mess with them, let's just stick it there.
Hey, do you need sticky notes?
Ms. Chase, I'm just moving this so
Okay,
you
that's
can see it from where you're sitting, you don't have to come back down, okay?
Thank you.
Ms. Chase, at the time of the, Ms. Chase, you lived in an apartment off campus during your time at Steelton State, right?
Yes, I did.
And this was the same apartment that you were hosting your party at the night of the accident.
Yes, it was.
And you said that this cake party that you were throwing that night had about 75 people there, right?
Yes.
And at this party, you had a large selection of alcohol.
I mean, we only provided the keg, but yes, there was other alcohol available.
And other alcohol, you mean you had the cheap rum
Yeah, there was some pretty cheap rum.
and the malt liquor.
The Johnny Walker Blue, yes.
No, and malt liquor,
Yes.
and then that really expensive scotch.
Yes.
And you admit from this selection, you had probably 4 to 5 beers,
Yes, I would say I had 45
and you also had the shot of scotch, right?
Yes, about shots worth.
Okay. But the truth is, Ms. Chase, you don't know exactly how much alcohol you had tonight, do you?
Well, I know it wasn't more than 4 to 5. Like I said, I drank one every quarter of the game.
Okay. So now after throwing your party and drinking several drinks, you went for a drive downtown, didn't you?
Yes, I was on Route 60.
In fact, you stated before that that's fine, because just because someone has some drinks, that doesn't mean they can't drive, right?
I mean, that's why the BAC for DUI is .09.
That's your personal opinion, correct?
Yes.
Now,
Is it .08? No. Oops.
Quinn, do you normally wear your seatbelt when you're driving?
Yes.
Thank you. Now, it was dark out that night because it was 2 o'clock in the morning, wasn't it?
Yes, but there are street lights all along the way.
So the street that you were driving on was well lit.
I would say so, yes.
All right. Now, on your way to your 2 a.m. meeting, your phone rings.
Yes, it did.
And of course you answer because it's Chris, right?
Yes.
And in fact, and when Chris called, he was changing up the plans on you, right? He wanted to go somewhere else?
Well, originally we were supposed to meet at Montana Max's, but it was a little crazy, so we decided to meet elsewhere.
And you continued on this conversation until the wreck happened.
It was on my Bluetooth device, but yes, we were talking.
All right. Now, so at this point in the night, at this point in your trip, you're focused on 2 different things, right? Driving at 2 a.m. and having your conversation with Chris.
I mean, that's why the Bluetooth was there, but yes, I was talking.
Now, Ms. Chase, you've been to Montana Max's before, right?
Yes, one other time I have been there.
And you drew this diagram of Max's in the intersection for us, right?
Yes, I did.
And this wreck happened at this intersection, correct?
Yes, it did.
And this intersection this is the intersection right outside the parking lot of Max's?
Yes, Max's is over there to the left, and then there are the 2 parking lots.
Right. But you've said before that you're not very familiar with the parking lots at Max's, right?
No, not really, just the main road.
There's at the intersection the accident happened, there's a 3-way traffic signal controlling the flow of traffic.
Yes.
Which means that if you had the green light like you claim you did, the lane coming out of the parking lot, if there was a car there, they were stopped at the red light, right?
I would assume so, but I did have the green light, so the other one would be red.
But you didn't see Albertson's vehicle prior to the accident that night, did you?
I mean, not until it T-boned me and pushed me into the other lane.
But if you had the green light and your eyes were forward and the other lane had the red light, the only place Al Overton's vehicle could have come from was this parking lot, right?
I mean, I wouldn't really know. I guess they could come from another parking lot or behind me or from the other side of the road.
But in order to hit your vehicle at this intersection in this spot, when you had the green light, Al Overton, the only place his vehicle could have come from was this intersection, or from that lane, right?
I guess that was where he did come from and hit me.
So isn't it true that had you not been distracted by your phone conversation, you would have seen Al Overton's vehicle that night?
No, I mean, he came out of nowhere and hit me.
Well, if it wasn't the phone conversation, then it must have been the alcohol in your system that caused you not to see Al Overton's vehicle that night.
I don't think so.
No further questions, Your Honor.
Redirect.
Ms. Chase, how were you hit?
Well, I was T-boned by the other car and pushed into the other lane.
How could have you avoided being T-boned in this intersection?
I mean, I was doing everything right. I had the green light. I was paying attention, using a hands-free device, and I got hit.
You stated that the light was green. What does a green light indicate to you?
That I have the right of way and I'm allowed to go through the light.
Thank you. I have no further questions for this witness. May she step down?
Yes.
And at this time, we'd like to enter this as plaintiff's exhibit 2.
Okay. Any objection?
No objection.
Where would you like us to tender this?
Just turn it around so the jury can't see it and put it right there.
I was like, so is she, this point of it, right? So it's not.
Any other witnesses for the plaintiff?
No. At this time, the plaintiff rests.
Okay. Any mid-trial motions?
Your Honor, at this time, the defense moves under Rule 50 of the Federal Rules of Civil Procedure for a judgment as a matter of law. The defense contends that following the presentation of the plaintiff's case, a reasonable jury would not have the evidentiary basis to find for the plaintiff on the issue of negligence.
Okay.
Your Honor, we have established through direct and circumstantial evidence that Al Overton was served, shot after shot after shot, held up his keys indicating that he was leaving the bar after displaying signs of intoxication through stumbling, knocking over drinks, vomiting, and left the bar holding his keys up indicating he was driving willingly.
Lauren, you can sit. I mean, you did not.
Oh, sorry, I thought it was on a drink.
No, you don't.
I thought we both stand.
No, no,
Okay,
no.
sorry
Whoever's
about that.
addressing the court. No.
Sorry.
Therefore,
You can keep drinking, you're fine.
therefore providing enough evidence for a reasonable jury to decide whether or not Montana Max was negligent or that a reasonable person would have acted differently in the circumstance.
What about that?
Your Honor, Your Honor, a reasonable person given the circumstances provided by the evidence in this case requires that someone witnessed Al Overton served alcohol while visibly intoxicated. We haven't heard from a single person today that was there that night or witnessed Al Overton while he was visibly intoxicated or served at that point. Therefore, the plaintiff hasn't presented a scintilla of evidence on this issue.
Isn't that for negligence per se, though?
Your Honor, that would be for the heightened standard of negligence per se, where we have to establish that a patron was served while displaying signs of intoxication. In
Indeed.
this case, it's just a reasonable, prudent person in the circumstances, which we've established through our expert, through several lines of questioning, what a person with TIPS training would have done, what a person with the policy training would have done, and what a just reasonable person at a bar would have done, and how Montana Max failed to act in those reasonable manners.
I was saying, didn't you drop per
Yes.
se before this trial started? Okay. I'm gonna overrule that motion at this time.
Thank you.
Let's take 5, and then we'll get started on the second half.